Our speaker tonight, Ilya Shapiro, is a senior fellow in constitutional studies at the Cato Institute, and he's the editor-in-chief of the Cato Supreme Court Review. Before joining Cato, he was a special assistant advisor to the multinational force in Iraq on rule of law issues and practiced international, political, commercial, and antitrust litigation at Patton, Boggs, and Cleary Gottlieb. Mr. Shapiro is the co-author of Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and the Constitution. He has contributed to a variety of academic, popular, and professional publications, including the Wall Street Journal, Harvard Journal of Law and Public Policy, the LA Times, USA Today, National Law Journal, Weekly Standard, the New York Times Online, National Review Online. He also regularly provides commentary for various media outlets, including CNN, Fox News, ABC, CBS, NBC, Univision, and Telemundo, the Colbert Report, and NPR. That's how you say it, Colbert?
Colbert Report.
Colbert? I don't know.
Colbert Report.
It's French. Do you speak Spanish when you were on Telemundo and all that? Very good.
Sí.
Mr. Shapiro has provided testimony to Congress and state legislatures and is coordinator of Cato's Amicus Briefs program. Filed more than 100 Friend of the Court briefs in the Supreme Court. He lectures regularly on behalf of the Federalist Society and other groups, is a member of the Legal Studies Institute's Board of Visitors at the Fund for American Studies, was an inaugural Washington Fellow at the National Review Institute, and has been an adjunct professor at the George Washington University Law School. He holds an AB from Princeton University, an MSc from the London School of Economics, and a JD from the University of Chicago Law School, where he became a Tony Patino Fellow, whatever that means. Mr. Shapiro is a member of the bars of New York, District of Columbia, and the United States Supreme Court. I'm going to present Mr. Shapiro. He didn't want a long introduction anyway, but Ilya Shapiro. Thank you.
Thanks so much. Thanks for having me. It's great. I love these events in the evenings, especially at a bar. I encourage you, if your drinks are low, I don't know if there's, knock on that door. I won't be offended if you have to leave to get another drink, because I've found that the more my audience has had to drink, the wittier I am. I am going to give you kind of an overview of what's going on in the Supreme Court. So it's going to be going by quick, the various cases, the various issues. I'm going to try to leave a lot of time for Q&A, because I don't know what you're particularly interested in, but I'm happy to answer questions on all and any of it. This last term, I want to set the scene before we come to this term's cases about sort of where we are at the court. This last term was one of almost big cases. We kind of had a couple of years where there was like a lot of really big cases on Obamacare and immigration and voting rights and gay rights, all these different things, affirmative action. This last term was a term of almost big cases, whether that be in affirmative action or campaign finance or Obamacare, whether because of the questions that were actually presented to the court in these various cases or in how the court narrowly decided them, there weren't really any blockbusters. I mean, you hear about Hobby Lobby, for example, very important case for religious liberty in the context of Obamacare, but at the end of the day, not a huge significant case in terms of jurisprudence or the Constitution or precedents for the future. And I say this having, as was described in my intro, written a book on Hobby Lobby. But it's not, it's gotten a lot of interest, but it's not a huge blockbuster case. The term did show kind of a recent trend of how President Obama is building consensus He campaigned in 2008 that he was going to transcend partisan divisions and be the president for all of the United States, and at least with respect to the Supreme Court, he has succeeded. At a record pace, the Obama administration has lost unanimously at the Supreme Court. He has brought together the left and the right, appointees from different years and different presidents and different parties. Part of this is because of the outlandish, envelope-bursting arguments that the Solicitor General's office has brought. Part of it is the outlandish, envelope-bursting decisions that Obama appointees in the lower courts have made for the Supreme Court to unanimously reverse. But again, President Obama has scored unanimous rulings against the federal government at a rate double that of President Clinton and triple that of President George W. Bush. So, bringing the country together. Now, despite the predictable ideological division over certain cases, like Hobby Lobby or like campaign finance, the McCutcheon case last term, which is again was a near blockbuster. Some people said it was the second coming of Citizens United. It really was not. The McCutcheon case in campaign finance last term involved a challenge to aggregate donation limits. That is, not how much you can give to any one candidate, but as a whole, how much you can give to all candidates across the country in federal elections. The limit was about $123,000. If you have that much money to spend on political campaigns, I'm hoping maybe you direct some of that to the Cato Institute, earmark it to the Center for Constitutional Studies and my amicus program, or maybe even the Ilya Shapiro Retirement Fund. My wife and I are buying a house next week. I'm happy to arrange for places for you to put your money that would be productive. But anyhow, only 636 people in the entire country maxed out at that aggregate limit. And since the Supreme Court 5-4 struck down that limit, those 636 people are now freer to spend more money on election. But again, this is not a huge, big change like Citizens United sort of was in terms of liberating independent speech. So again, some of these cases are indeed ideologically divided, even if they're not necessarily blockbuster cases. But this past term recorded a level of unanimity on the court, as I said, Obama scoring bringing the country together. The level of unanimity on the court was not seen since the 1940s. 2/3 of the cases ended up in unanimous judgments. Okay? Now, not all of those judgments did everyone agree on every little bit of the opinion and the reasoning. Indeed, in some of these cases, you had concurrences that were dissents in all but name. Very important cases on recess appointments or abortion picketing, or this weird case about using a treaty against chemical weapon proliferation to prosecute this lady who tried to hurt her erstwhile best friend who had gotten pregnant by her husband, this weird sort of situation in suburban Philadelphia. But anyway, it shouldn't have been a federal case. Anyway, these sorts of cases ended up with strident, very vehement concurrences. There were 9-0 in the judgment, but not in the reasoning. But even if you only count the cases that were unanimous in all parts, not a single concurrence, let alone a dissent, that still was about 38%, which is, I haven't gone through the whole history of the Supreme Court, but it's a high for at least going back 30 years. So there is something to this idea that the court is, as Chief Justice Roberts hoped for and promised at his confirmation hearings, that the court is speaking with more of one voice. Now, part of that is the narrowness of the rulings that they're issuing in some of these cases, which is prompting especially Justice Scalia, for example, to say, oh, come on, you need to be ruling more broadly. You can't rewrite a statute into a tax every single time, which Chief Justice Roberts has done not just in the Obamacare case from 3 terms ago. But I think even more of this dynamic is attributable to the court being able to control its own docket. Remember, it's the only court in the country, the only federal court in the country, that gets to decide which cases to take and which not to take. And increasingly, this court is turning down cases that are hard or that would almost certainly result in split opinions, whether ideological or otherwise. And I don't just mean in kind of high-profile cultural war issues like Second Amendment, gun legislation, or gay marriage. There are a number of fascinating cases that have come along the last couple of years, and especially this past term, that the court simply did not take. It takes 4 justices to vote to take a case, and those votes weren't there. Instead, we had about 10% of the docket on patent cases last term. Now, I don't know if any of you are IP lawyers or patent lawyers. Important cases, important issues for the patent bar and what have you, but not sort of the, world historical issues that a lot of court watchers are hoping for, or expecting, or that affect the way that the government acts, or the relationship between even state governments and individuals. So that's certainly something that a lot of us are, regardless of what your ideological position is, that are frustrated about with this court. Nevertheless, 10 cases last term did go 5-4, and those are a lot of the high-profile rulings on campaign finance, legislative prayer, workers' rights, Obamacare's contraceptive mandate, and what have you. So basically, you take away the cases that are unanimous and the ones that are 5-4, and there's very little left. This last term, more than even previous, and that's an increasing trend on both sides. Justice Kennedy was in the majority in every one of those 5-4 decisions, 4 times with the conservatives, twice with the liberals, and 4 times in heterodox, unusual, sort of unclassifiable alignments. Although the Chief Justice was very close to Kennedy. And Chief Justice Roberts, along with Elena Kagan, the most junior justice, have never, in their entire time at the court, written a solo dissent. That is, those cases that go 8-1, that one has never been Roberts or Kagan. Kagan, however, and Justice Alito, who's the most junior justice of the conservative bloc, if you will, I think really came into their own this past term. Justice Alito wrote the majority opinions in Hobby Lobby and Harris versus Quinn, this big labor law case that I'll talk about in a moment, which I think is the biggest case of the term, by the way. And Justice Kagan wrote the lead dissents in Harris versus Quinn and in Town versus Greece, Town of Greece. Both of these justices write very clearly, whether you agree with them or not, and they ask very perceptive questions. If you're following along with oral argument, if you're at the court or listening to the oral argument later on audio record or reading the transcript, hone in on what Alito and Kagan are asking, because chances are those are the sorts of issues on which the case will turn, regardless of whether it's unanimous or 5-4. All right. Now, moving to the cases, I thought I'd start with ERISA and bankruptcy, maybe some tax, and perhaps some key TAM cases if we have time. I'm kidding. All right, so before I leave last term, I do want to say a few words on what, as I said, I think is the biggest case of the term that you might not have heard about because it was decided the same day that Hobby Lobby came down, right? Hobby Lobby was about how employers have to fire women that use birth control and things like that. Right? At least that's what my Twitter feed said. Anyway, if you want to know more about Hobby Lobby, I'm happy to tell you, It's a bizarre. It's really a simple case of statutory interpretation. It has nothing to do with balancing rights or whether religion trumps everything. I mean, it's just been so misunderstood, especially the corporate rights bit, of which the Supreme Court ruled 5-2 and really didn't spend much time on it at all. But the really big case that I think is going to have jurisprudential legs going forward is this Harris versus Quinn case. This is a case out of Illinois. About a dozen states had these sorts of laws until the Supreme Court ruling that said that independent contractors who get paid out of state funds can be forced to join unions and pay union dues. In this case, it was home health care aides who were hired by, their terms of employment were controlled by people that they worked for. Oftentimes it was their own relatives, a disabled child, an elderly parent, and they were the main caregiver and got compensated out of state Medicaid funds. But these reimbursement rates, hourly rates, were negotiated by a union, by the SEIU in this case. And the argument was that that makes them susceptible to being forced into joining the union like actual state workers are. Someone who works at the DMV or some other state agency, correctional officers say. And the court ruled 5-4 that no. It shed a lot of doubt on the underlying ruling that even allows compelled unionization of any workers, even of policemen and teachers and direct people who all of their employment terms are controlled by the state. It's a curious, for those of you who might be labor lawyers or who are interested in this area, the Abood case, Abood versus Detroit Board of Education from the 70s. The court sort of reinforced, without examining it, a precedent from the 50s about the government's interest in preventing or in preserving labor peace. You would have unions in the 50s that would literally fight each other to sign up workers. And so in the interests of labor peace, the government gave monopoly power to certain unions and compelled unionization along with that. Well, here the court struck down compelled unionization for, as I said, independent contractors that were paid out of state funds. Very strong precedent that builds on a couple of other rulings from the past 5-7 years that I think in the right case in the future will be another example of the Roberts Court incrementally moving towards shifting the constitutional discussion in very significant ways, not the first time that it gets that bite at the apple. All right, let's move to this term. And until very recently, until about a month ago, this term was going to be one of the, certainly the most boring one in at least 5 years or so, which I thought was okay. I had some longer term projects I wanted to work on. I thought I could invest time in doing other sorts of things than just commenting on like huge blockbusters all the time. It's okay. But then the Supreme Court granted, in the course of 3 days, the Supreme Court granted cert in an Obamacare case, and then the Sixth Circuit, based in Cincinnati, became the first federal appellate court to uphold state marriage laws against constitutional challenge, making it almost a certainty that the Supreme Court will take a gay marriage case. The question is whether it'll make it into this term or the next term. So all of a sudden we have these big cases. But before I turn to those cases, let me tell you about some of what would have passed as the highlights of the term. In the election law area, some states, I don't think New York is one of these, has independent redistricting commissions. Some of them are appointed by the legislature, some of them are independently appointed in various ways. Well, Arizona, the independent is the wife of a leading state Democratic Party official who had switched her registration 10 years previous, so that 10 years hence she would qualify as an independent for this redistricting commission. She ended up being impeached by the Arizona State Legislature, and the Arizona Supreme Court reinstated her. So there's a huge political windstorm sort of going on here. Arizona, by the way, is the state in the country that is most disproportionately represented by Democrats, at least relative to the voting strength. Romney won Arizona. If you go kind of by the ratio of the vote to how many congressional seats it's supposed to have, it would be about 6-3, maybe 7-2 Republican. Instead, it's 5-4 Democrat because of the way that the Redistricting Commission acted. I believe Pennsylvania is the most heavily slanted the other way. That is, it's gone reliably Democratic in presidential elections, but its congressional delegation is something like 15-6 or something along those lines, again because of the way that districting works and also the way that populations are compacted. But anyway, that's kind of an interesting issue for election lawyers. Another election law case comes from Alabama. 2 terms ago, remember, the court disabled Section 5 of the Voting Rights Act. That is, that the states that had been under federal pre-clearance or receivership, effectively, that had to clear every election law change with the federal government, with Washington, with the Justice Department. They no longer have to do that. Part of that, part of the jurisprudence under the Voting Rights Act said that once you have a certain percentage of racial minorities in a given congressional seat, the presumption is you can't lessen that percentage because that lowers the, quote, ability to elect the candidate of your choice for those racial minority groups. So here we have the Alabama legislature, when it redistricted, it kept all of the majority-minority districts majority-minority. In fact, it enhanced them. And thereby, it essentially harmed white Democrats. All the, or almost all of the Democrats in Alabama congressionally, certainly congressionally, but also at the state legislative level, I believe, are members of minorities. And so the challenge is, can you do that based on political considerations, not necessarily racial ones? And again, it's kind of a weird circumstance where you have, for a long time, the leaders and the lawyers representing racial minority groups would take redistricting efforts to task if they didn't create enough of a critical mass in given districts of the minority groups so that they could elect so-called candidates of their choice. And here they're saying that the state is doing too much of that. Ironically, again, this is to protect white Democrats, but of course if the point of our election law is to protect white Democrats, then we never would have passed the Voting Rights Act in the first place. Let that sink in for a second. The Facebook stalking case, or the Facebook threats case that was argued last week, maybe some of you have heard of this. You kids especially active on social media, this might have a large precedent in your life that you don't even realize, 10, 20 years down the road when one of you is running for Congress or something. Alonis is the guy's name, Alonis versus United States. So Anthony Alonis in Pennsylvania was distraught after his wife left him and took their little kids with her. So he got on Facebook and he's a big fan of rap music. No, I'm not, but he is, and he emulated various rap artists, including Eminem, who I'm sure some of you have heard of. I've at least heard of him, and sort of wrote these kind of violent, aggressive, vituperative sort of lyrics. And he styled himself as Tone Dougie. His name is Anthony Douglas Alonis. He called himself Tone Dougie. And he said, this is a parody and this is a joke. And he linked like the Wikipedia page to free speech and stuff like this. But really, angry, really disturbing stuff. I mean, if you look at this stuff just without knowing anything, I mean, you would think, oh my gosh, this guy's going to kill his ex-wife. He is going to, at one point he threatened a kindergarten class. He just said, which kindergarten class should I target for shooting up or something like that. An FBI agent at one point visited his home and, didn't find any untoward behavior when she was talking to him and whatnot. But later he composed another rap lyric, against the FBI agent or something like that. Now the government didn't prove that he was collecting guns or bombs or doing anything of the sort, but it did charge him with making a threat, publishing a threat in channels of interstate commerce like Facebook. The federal government did, and he was convicted under 4 of the 5 counts on which he was charged. The one count that he was acquitted of involved threatening the amusement park that had fired him. Yeah, this is the other thing about this case. He had worked at an amusement park. Really, just interesting facts about this case, right? You can't argue the law, so you have to talk about the facts about these cases, right? The issue here is it enough for the jury to find that an objective person, a reasonable person, would find what he wrote threatening, in fear of their life or what have you? Or do you have to find, does the government have to establish a subjective intent to threaten, or a recklessness, knew or should have known that these words would have caused fear, apprehension, these sorts of things. The mens rea, to get all technical. Very interesting kind of coalition of supporters on either side of this. Cato filed a brief supporting the defendant here, saying that we don't want to punish people, if they have no guilty mind. Most of the groups siding with the government were prosecutors' groups, understandably, and domestic violence advocates. So we'll see what happens there. But this is certainly an unusual sort of statute under which he's being charged, and again, unusual sorts of facts. I mean, you look at, again, reading the stuff in the abstract, it's really ugly. But then you kind of learn about everything that was, everything else that he was getting likes for these things because he was, parodying this. Some of Eminem's rap lyrics were no less violent in terms of threatening his wife and his mother and things like this. And is the difference that was a professional, but this is an amateur? And how do you draw that? So really interesting sort of First Amendment issue. Moving from that to a fishy kind of case, literally. Yates versus United States. This fisherman in the Gulf of Mexico, was cited by the Fish and Wildlife Service for catching undersized grouper. You have to be 20-inch that you can catch, and I think he caught a few that were 18 and a half, 19 inches. So, it's just an inch short. That can get awkward, right? And fine, so he got cited by the Fish and Wildlife Service, fine. But by the time they got back to port to process the paperwork and give him his citation, what have you, the inspectors could no longer find the undersized fish. Presumably he had thrown them overboard to, destroy the evidence of the fish, presumably, right? So was he, further charged with destroying evidence under whatever state statute? No. He was charged under the record-keeping provision of Sarbanes-Oxley, the financial crimes and accounting legislation, right, that was passed in the wake of the accounting scandals. I think this was the same prosecutor that was transferred from Philly who went after that woman with the chemical weapons treaty. Just very zealous. So, it's an issue of statutory interpretation and whether the statute which criminalizes, makes it a crime for someone who, quote, knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object with the intent to impede or obstruct an investigation. Clearly it was intended for the financial services industry, but it says tangible object. A fish is a tangible object. Can you read it that way, or does that make it overbroad or something like that? So the court really was kind of in a pickle. I don't know how to predict this one, honestly, from oral argument. Moving to another funny government agency, Amtrak was before the court yesterday, actually. I don't know if you read about this case, Department of Transportation versus Association of American Railroads. Now, I don't know if any of you are fans of the Passenger Rail Investment and Improvement Act of 2008, but that particular piece of legislation, and another winner, delegates not just to the Department of Transportation, but also to Amtrak, the regulatory power to set certain metrics and standards for Amtrak's performance. Basically, if Amtrak's performance lags too much, blame the freight rail companies with which it shares the tracks. So it gets to essentially, with the Department of Transportation, who knows how much they share the power, gets to write the rules by which, its competitors, for the rail at least, operate. There are a lot of issues here. Is Amtrak a public agency, for example? Because a lot of this implicates the non-delegation doctrine, right? And the court hasn't struck down a piece of legislation based on Congress delegating too much power to the administrative state since 1936, before the New Deal revolution that expanded government power. So, presumably if Amtrak can be considered a government agency, maybe it gets off scot-free. On the other hand, it's a government agency that competes in the marketplace. And there's a lot of other types of precedent, not involving writing your own rules, but precedent about what happens when the government acts in the marketplace. Immunity attaches differently. It can be, First Amendment issues are treated differently, a whole host of things. So, Amtrak is kind of sui generis anyway. I mean, there's very few entities that are quite, quasi-governmental in the same way. The Postal Service, maybe, I don't know. And this particular statute is unique as well. So, interesting sort of case on its face, but I think the Supreme Court will find some narrow way of ruling that satisfies nobody again and doesn't set a long-term precedent. This is a pretty big one. Disparate impact in housing, the Fair Housing Act. The court has really tried to decide this issue several times over the last few years, and the Obama administration has always pressured the plaintiffs to settle because they know that the court is likely to rule against the use of disparate impact. Disparate impact is a theory that you're liable for racial discrimination, not just if you intend to discriminate on someone based on their race, treat them differently based on their race, but if you have a completely neutral action that happens to have affect a statistical disparity in terms of race. So this has come up in New York right now, out of Buffalo. There's a case pending before the Court of Appeals involving a completely neutral promotion test. Nobody argues that the test was biased anyway. Neutral promotion test, but a disproportionate number of white firefighters happened to have passed it to be eligible for promotion. In the city, this happened in New Haven, Connecticut 5 years ago that the Supreme Court ruled on. Ricci versus Stefano, same sort of thing. The city, rather than promoting the firefighters that qualified, they didn't want to get sued by the black and Hispanic firefighters, so they just didn't promote anybody and let the test lapse. Same sort of thing under the Fair Housing Act. The Fair Housing Act is some civil rights law legislation actually includes disparate impact language. The Fair Housing Act doesn't. There's a split in the lower courts, and it's quite likely because here the party that's being sued is Texas, and they will not settle. Therefore, the Supreme Court will have a chance, I think, to resolve this issue. One more case before I get to the biggies. There's an antitrust doctrine that says that states and private parties acting under the color of state law are immune from prosecution under federal antitrust law. This is the Parker versus Brown doctrine from the 1940s. So private parties can create cartels as long as they're effectively government-sanctioned cartels, like the Bar Association, that sort of thing, right? Beginning in 2003, the North Carolina Board of Dental Examiners started issuing cease and desist orders to non-dentists who were performing teeth whitening services. Okay, these are sorts of things that you can go to your local CVS or Walgreens or I don't know what the local pharmacies are called here. CVS, sure. And there you go. And you can get Dwayne Reed, I guess, in the city. You can get these teeth whitening strips, right? That sort of thing. You can get that over the counter by yourself. But the dentists issued cease and desist orders to hygienists and other people that were doing this without a dentistry license because teeth whitening is a highly profitable service that dentists perform, so they didn't want to be competed with. And there's no issues of safety here. It's not like you leave the strips on too long and your teeth explode or anything like that. But they wanted to limit competition. The Federal Trade Commission charged the Board of Dental Examiners with anti-competitive conduct. And the Fourth Circuit rejected Parker immunity, this antitrust immunity doctrine. It's incredible. So for the first time since I can imagine, certainly during my time at Cato, I've been there over 7 years, Cato filed an amicus brief supporting the federal government, supporting the Federal Trade Commission against this state-designated cartel. In favor of economic liberty. Well, we'll see what happens here. I mean, I think the reason the court took this case is because lower court rulings on Parker immunity are all over the place, and the Supreme Court hasn't taken a case in this area since it set out the doctrine in the 40s, as I said. The court also recently took a case involving Confederate license plates in Texas. So we'll see what kind of First Amendment. The Texas Solicitor General actually was defending the practice of not issuing Confederate license plates. So it's Texas versus Confederate veterans or Sons of Confederate Veterans or something like that. One of these bizarre cases that... all right, so the two big cases. The Obamacare case. This is not a constitutional challenge to anything, individual mandate or otherwise. Here's what this case is. It's called King versus Burwell. There's a companion case. King is out of the DC, out of the Fourth Circuit. Hulbig is a companion case out of the DC Circuit. So the way that Obamacare is written, it has all of these complicated subsidies and tax credits and income transfers and things like this to, allow people to pay for the higher cost of health care due to the increased premiums from having to cover, people and not being able to assess premiums underwritten based on risk and all these other things, right? So people who buy their insurance in exchanges, quote, established by the state, are supposed to get tax credits from the IRS to enable them to pay those premiums for insurance policies from exchanges, quote, established by the state. Well, 13 states deemed it advantageous to establish their own exchanges. 36 states did not. So that put the government in a conundrum. We had the vast majority of people in the country not in state exchanges. That's where healthcare.gov came from. That was the federal exchange, right? Because the federal government could not command the states to set up their own exchanges. That would violate the anti-commandeering principle. So it set up these federal exchanges, and the IRS initially it decided it wasn't going to do this, but then after pressure from political appointees, it's changed its mind and issued a ruling saying that federal exchanges, people that bought their insurance from federal exchanges, were also eligible for subsidies because the phrase exchange established by a state was the same as an exchange where the federal government established an exchange on behalf of the state, basically, is the argument. And moreover, why would the government create the Affordable Care Act if lots of people weren't going to be able to afford the care? The answer, by the way, to the extent it's even relevant, because it's a statutory construction case involving the text of the very clear statute, is that there are a lot of programs around the country, historically, where states are incentivized to join the federal program with their bribed with a lot of money. If they don't join the program, they don't get the money. This was essentially the same apparent, to the extent anyone knows what was going on in the Obamacare drafting, was apparently what was going on. But again, there was a circuit split between the DC Circuit and the Fourth Circuit. The DC Circuit, with Obama's PAC nominees, eventually went en banc, but the Supreme Court took the case because I think it recognized there were two other cases coming up behind these two, one from Oklahoma, one from Indiana. The 10th and 7th Circuits were certainly not going to be sympathetic to the government, and so they were going to face this issue anyway. Anybody's guess. I guess we can speculate what's going to happen here. My prediction is worth what you're paying for it. I think I'm 80% or more confident that these tax credits will be struck down. It might even go 7-2, like the Medicaid expansion part of the NFIB versus Sebelius case. I think that contrary to the constitutional analysis in the previous Obamacare case, here, a John Roberts, for example, who bends over backwards to allow Congress to do what it wants to do, kind of an Oliver Wendell Holmes, I'll bend over backwards, if the people want to go to hell, I'll help them go there sort of thing, will help the people do that, good and hard, rather than deferring to the agency. Deferring to Congress is different than deferring to the executive agency. At least that's what I think will happen. But who knows? Stay tuned. Argument's going to happen in March. And finally, on gay marriage. So now there is finally a circuit split that just arose less than a month ago. There are currently 37 states, I believe is the count, 35 or 37, depending on a few district court rulings that implement some circuit court rulings that recognize, that require the recognition of same-sex marriage. The Sixth Circuit ruling was the first federal appellate court that ruled the other way. Therefore, we have a split. It's kind of on the edge, timing-wise, of when the court puts cases on its docket for this coming term. Generally, if it grants before mid-January, it'll still make it onto the argument calendar for this term. I think there will be some sort of compromise where they have to grant, but the court wants to buy as much time as it can, because popular opinion on this subject just shifts incredibly rapidly. I think we won't have argument until next October, with a ruling probably by Christmas around this time of next year. But who knows? I think the court will want to avoid an opinion right in the middle of the presidential election in June 2016. Who knows if December 2015 will be any different, but that's my prediction on what will happen. And the court will, I think, side with the challengers to the state marriage laws. It's hard to see Anthony Kennedy, who wrote the opinions in Lawrence versus Texas, and Romer versus Evans, and Windsor versus United States, the big gay rights cases in the last 15 years. It's hard to see him going the other way on this. If you want to know my view, if you want to know Cato's view, we've been filing briefs specifically on the Equal Protection Clause. That is, not about the fundamental right to marry or the importance of love or anything else, but this is a government action. We prefer government not to be involved in marriage, but if it is, it has to provide this license equally. Now, before I conclude and take your questions about the Supreme Court or other constitutional issues that might be concerning you, I think I'd be remiss if I didn't say a few words about what some are calling the Supreme Court's libertarian turn, both those alarmed and those cheering this trend. Simon Lazarus, who's kind of a progressive legal activist, sounded the alarm in the pages of the, well, now defunct New Republic by calling out the growing threat of libertarianism and its seismic influence on the Supreme Court. I hope he's right. I hope we're having a seismic influence. But certainly, in the range of issues, from campaign finance to gay rights to political speech to labor rights to, I mean, you name it, there has definitely been a lot of good rulings in recent years. Cell phone searches, right? Unanimous ruling against warrantless cell phone searches. Whole host of things. And indeed, Cato amassed a 10-1 record last year in our amicus briefs, 15-3 the year before. This is against the Solicitor General's office, the government's representative before the Supreme Court, which won fewer than 40% of its cases 2 years ago and improved to 11-9 last year. And by the way, Cato was the only organization, and I was the only lawyer to file briefs on the winning side of each of the big three cases of the last two terms. This past term, that was McCutcheon, Harris versus Quinn, and Hobby Lobby, the big 5-4 cases. Similarly, the term before. And as I said, the government is losing unanimously at a record rate. Part of this is because, then that's probably a libertarian thing if the government loses. Part of that is that Kennedy tends to be libertarian on the close cases. I wouldn't call him libertarian overall. There's a whole other talk I give about Justice Kennedy. I sort of use him as my magic 8-ball. I have a bobblehead Kennedy. I need to make a decision. I see whether it shakes its head or not. He tends to be libertarian in those 5-4 cases. Outlandish executive actions that come before the Supreme Court, and these sorts of arguments that are made. One commentator said that when you have a crazy client that forces you to make crazy arguments, you're going to lose some cases. And that's happening. I think the government would be better served following our lead on constitutional and statutory interpretation, advocating positions that reinforce our founding document's role in securing and protecting individual liberty. Thank you. I was going to get my wine, but...
You're going to need it.
Questions? Complaints? Yes?
Justice Ginsburg, is she immortal or something?
Yeah. How much longer is she?
Well, let's hope she hangs on for 2 more years.
When I was talking to her doctors last night, Ruth Bader Ginsburg has been called frail since she was 15 years old. God bless her. 2-time cancer survivor, just had a stent inserted in her heart. I don't know.
But as far as the court,
here's my prediction. She has said that she will do her job unless she senses some sort of physical or mental deficiency. Which doesn't, ideological deficiencies don't count as. There's no indication that she has, slowed down. She's active in questioning. She gets her opinions out faster than anyone else Maybe she hires faster clerks, I don't know, but there's, it's not an indication that her clerks are controlling her. I mean, what you see is what you get from her, for good or ill. So who knows when it'll happen. Here is sort of my game planning of what will happen when it happens. If she survives this term on the court, I think the Republicans in the Senate won't allow a replacement to be confirmed until the next presidential election. That's just my prediction. Unless Obama nominates kind of the most milquetoast, Democratic appointee he can, like, for example, Merrick Garland of the D.C. Circuit, who's a white male in his late 50s, who's fairly moderate as far as Democratic appointees go. I could see someone like that getting through, because the devil is better than whoever a potential President Clinton could appoint in 2017. Short of something like that, I really could see a kind of divisive, year-long presidential election campaign about the Supreme Court. Which wouldn't be that unusual, or the vacancy on the court wouldn't be that unusual historically. We think it's kind of odd to have fewer than 9 justices, but in the 40s, 50s, 60s, you'd have a lot of opinions that were decided 5-2, 6-1, people, and not because of recusals, just because people were in hospital, or for some other that they resigned quicker. There would not be a full complement of justices as much. What this would mean, of course, is that all of those close culture war or other necessarily very split cases would have to be held over until there was someone confirmed. So, if I'm correct in my assessment of the gay marriage cases, that they won't be argued till next term, and if Ginsburg resigns or is incapacitated, say, over the summer after this term ends, then logically my prediction would be that gay marriage wouldn't be decided until the next Supreme Court term, the one starting in 2016. I don't know, but that's, as best as I can play that out, that's, kind of armchair politicking.
Were there more unanimous decisions than 5-4 on this latest go-around?
Way more. 2/3 unanimous.
Since the Supreme Court gets to pick their cases, are we looking at some coincidence that is driven by the facts and the law that results in these unanimous decisions, or are we looking at some conscious consensus on the part of the justices when they pick the cases in order to are they looking at a case and saying, regardless of the fact we haven't heard any arguments yet, based on these briefs?
Four things. Four things.
Are they consciously trying to get unanimous decisions?
Yes.
And is that a good thing?
They are, and especially Roberts is. So there's 4 things. One, they're taking outrageous lower court decisions, especially from the 6th, 9th, and federal circuits. Those get reversed just at very high rates. 2, there are really outlandish executive actions and government arguments at before the Supreme Court that is causing more unanimity than the government might still lose, but they had a shot at a 6-3 or a 5-4, but they went whole hog and lost unanimously. 3, the narrowness of the rulings, as I said, avoiding the constitutional decision or splitting hairs or rewriting the statute or what have you, which often causes strident concurrences, as I said. And 4, docket control. Yeah, if they see a case that looks, the conservatives aren't sure whether they'll have Kennedy's vote, neither are the liberals, they'll just deny it rather than give it the 4 votes for certain. Or Roberts sees that this is going to be a divisive case, and even if he's sure that his side would win, he'd rather not take it because he'd rather not have the division, that sort of thing. Is that a good thing? I don't think so. I don't think it's good for the court to shy away from deciding cases just because they would be split. Empirical research shows that 5-4 rulings are have no less precedential value or no less respected than unanimous rulings. Sure, they, if it's during the same court or within a very short time frame when you replace the one key justice, that could get overturned. But in terms of, will this past term's 5-4 rulings, are they more likely to get overturned 40 years from now than this past term's 9-0 rulings? No.
Okay.
As we discussed before you got up there, and speaking of ridiculous executive
Could
actions,
someone ask a bartender to get me more wine, please?
involving the
Michael, I don't know if he's around.
involving the amnesty question, okay, from a libertarian Cato perspective and from a Supreme Court question. We've all
Serve myself.
While you're over there, Mike, bring it over here.
All right, so we've seen the executive decision. Now there's a bunch of states suing against it. So one question is when is that likely, or is that likely to make it to the Supreme Court? But then there's the issue of the amnesty itself. I know you've written extensively on how it's different from Bush and all the other ones. And then, as we discussed, the whole Milton Friedman thing of immigration into a welfare state versus the libertarian open borders
Taking
perspective.
the last question first, my former colleague Dan Griswold, who worked on these issues a long time at Cato, said we should put a wall around the welfare state, not the country. And in fact, immigrants, including especially illegals, can't access the same welfare state programs that citizens can. And
they can in
including
California.
under Obama's new executive action. And even regardless of all that, studies have shown that even illegal immigrants are a net economic benefit on the country. There would be even more if the state and local welfare states weren't extended to them. But I don't think that's as much of an issue because almost all immigrants that are coming here to make a living. Otherwise, they would stay. They're not here to sit on the public dole or to commit crimes or what have you. Now, the legality of the executive action. I think it's illegal. Here's the problem. The immigration laws give the executive branch tremendous discretion, perhaps more than any other area of law. I mean, I haven't surveyed the entire federal U.S. code, but they give a wide variety of discretion in terms of prioritizing what kind of people to deport, in terms of deferring any actions against people that are of a certain class. That's been used by presidents since the modern immigration state began in the 60s of both parties in various kinds of situations, whether that be students who are not in compliance with their student visas in areas affected by Katrina under George W. Bush, whether that be military spouses and families under Reagan and George H.W. Bush, Haitians under Clinton during the unrest in that country. So there's a whole lot of leeway. But either there's not leeway to have a class of 5 million people or however many are affected by the president's action. Let's just be clear on what the president's action is doing. It's not giving green cards to 5 million people. It's saying that if you are the parent of a U.S. citizen or permanent resident child, you get to stay in the country until this president or the next president changes his mind, until the executive branch changes its policy. It's called deferred action. And you get to work. It's not a green card, it's a work permit. And you're allowed to stay in the country. That could change tomorrow with a different executive action, or it can change with the next administration. That's why, by the way, the Executive Dream Act, as it were, the original deferred action for people who were brought here as children and want to go to college or serve in the military, less than half of the people eligible for that have signed up because they don't want to give their information to the government, because eventually if that's rescinded, they could then be more easily rounded up and adverse actions taken against them. So again, either the discretion to have case-by-case deferral of deportation or what have you, or kind of narrow class deferral of delaying of action against them, it seems like it cannot possibly reach out to half of the illegal immigrants in the country. But even if it does, or if it does, then I think it's an unconstitutional delegation of legislative authority to the executive. Because then, in effect, the president gets to decide what laws to waive and which laws to enforce. Congress can't, for example, under the Constitution, pass a law saying the president gets to be dictator, even for a year, even in one area of policy. And so, again, that's my basic take on the executive action, is either it violates the statute or the statute violates separation of powers.
But with the lawsuits against it, do you think it,
So, I forget how many states, 17, maybe
Something like
20-something
that, yeah.
states have sued. The standing question is very interesting. That is, how do states have standing to challenge an executive action that seems to, violate, go beyond what the president's powers are, or violate separation of powers, maybe intrude on the federal legislative power, right? And their argument is, well, there was this case in 2007 called Massachusetts versus EPA, where Massachusetts, the Supreme Court held by a 5-4 vote, had standing to challenge EPA non-regulation of greenhouse gases on the theory that these gases cause climate change, and Massachusetts, being a coastal state, would lose land to erosion, to the seas rising. Well, if that's enough to establish standing, aren't certain states disproportionately affected by illegal immigration, and more specifically by Obama's executive actions? I'm not sure, because I'm not sure, it's not simply border states, because Obama's executive action, what does it do exactly to the state fiscs? Does it encourage more illegals to come over? I'm not sure. This might be an empirical question. I'm not sure how the court will look at that. I think the case will be ultimately decided, and it'll play its way through on the standing issue before it gets to the merits, before maybe Congress will find a legislative solution. Ultimately, I think it's, given that I'm certainly in favor of broad-scale immigration reform. I'm a double immigrant myself. I was born in Russia. When we were immigrating, we took a wrong turn to the St. Lawrence Seaway, so I'm a naturalized Canadian. Like most immigrants, I do a job that native-born Americans won't, in defending the Constitution. But the problem is, large-scale reform is made much less likely and pushed into the distance by this sort of action. I think it'll take someone like, a Ted Cruz in a Nixon to China sort of moment to ultimately have this kind of reform. And this is the last thing I want to say on this. The problem with Reagan's immigration reform in 1986 wasn't the amnesty, all right? It's more accurate to call it parole, because people aren't kind of getting off scot-free and there's no pathway to citizenship. And by the way, that's what the eventual compromise will look like. There won't be a pathway to citizenship. You can just stay here, and your kids will obviously become citizens, but maybe a pathway in 25 years or something like that. But people that come here don't come to become citizens. They don't, because what citizenship gives you that legal residence doesn't is voting, serving on juries, and forever paying income taxes. They don't come here for those reasons, right? The Democratic Party wants the voters, and that's the reason why they won't compromise on that. But eventual compromise, I think, will include those things. But the reason why the Reagan reform failed is because they offered this parole or amnesty to people who are already here. It did some sort of enforcement actions, but it didn't fix the problem of not having a legal way to get into the country. People are going to come, as long as America is the land of opportunity, and better both in terms of economic opportunity and rule of law opportunity than countries elsewhere in the world. They're going to keep coming. And the problem is, neither for skilled nor unskilled laborers is there a lawful path. I mean, I give a whole talk about, I've never taken an immigration law class in my life or practiced immigration law, but I've gotten a huge education just going through the system myself. It's not a matter of applying to some agencies saying, look at my qualifications and skills, I should qualify for a green card. You can't do that. It's either through marriage, and to my wife's relief, I'm sure I already had a green card by the time we met, or through your employer doing it. And for your employer to sponsor you, they first of all have to establish that no American has the minimal qualifications for your job. So there's all this kabuki theater with immigration lawyer games that are being played. I'm an unusual case. I went to Iraq for a few months. I worked on the Bush re-elect. I interned in the Senate. I clerked for a federal judge. I have all these weird contacts and things like that. So I was certified in the lightning quick time of 18 months as an alien of exceptional ability. I have a certificate of an alien of exceptional ability. That doesn't mean I can, zap you or levitate or something. But anyway, the system needs huge reform. Until Obamacare came along, I could unequivocally say that the immigration non-policy of this country was the worst part of the government. But I'm not very optimistic. You've been, yes.
I would just like to know how you stand on the Rumyecki versus Holder. Are you aware?
I'm sorry?
Rumyecki versus Holder.
I don't know that case.
It's the homeschool case.
The Germans, right?
It's very important to us because we have a table full of homeschoolers.
That area of law is really complicated. Not that everything I haven't talked about isn't really complicated, but I believe in the end they're getting some sort of humanitarian relief. Is that right?
They are, but it's what Holder, I believe, put on his statement that is of great concern.
Well, I believe that he's saying that there's no precedential value to what he's doing. It's just his family or something like that, right?
And that ultimately the educational rights don't really fall fully in the parents' hands.
They don't in this country.
Right, and now that's permanently, as I understand.
Well, a statement by the Attorney General isn't, that can be overturned by Congress, that can be overturned by a court. That's the weakness of an executive action in the first place. Yeah, it's like, people complain about, teaching evolution in schools or creationism in schools or, any sorts of issues whether with curriculum and now Common Core, No Child Left Behind. The problem is federal involvement in this area in the first place. The more that the government gets involved in areas that are controversial, the more sort of social clashes it creates. I don't know, under the law, the relevant statutes, what the right answer is in that case. It's a really close call, the way that the statutes are written. And also given Supreme Court precedent in terms of parental rights. Those aren't as strongly protected as perhaps we might like. It's an unusual case. So I'm sorry I can't give you much comfort or even a definitive answer one way or another. I think the ultimate solution is to have more education choice in general, and then to have Congress devolve more of those powers to the states, and states to devolve more of those powers to the parents. But the way the law is written now, it's I don't know Holder's specific statement, but it might be that a case-by-case disposition is sort of the fudgy correct way to go about it. I don't know, but it's not a black and white issue. Yeah.
What's the difference between the president's executive action and the Senate bill? And then, like, my own personal belief is, I find it really disingenuous that you have Republican senators such as Kelly Ayotte from New Hampshire who voted for the Senate amnesty bill, who are, complaining that the president's actions are unconstitutional because she basically voted for the same thing. And then, of course, House Republicans are coming out with their own amnesty bill. And I really find it disingenuous that they're like smacking the table saying the president's out of line, but, come January they're introducing their own amnesty bill.
Look, first of all, I think repeating amnesty again and again serves nobody's interests. We have one side shouting amnesty, the other side shouting racism, and we get nowhere. It doesn't. The current immigration system doesn't serve anybody's interests. It doesn't serve big business or small business. It doesn't serve educated people or uneducated people. It doesn't serve national security or the economy. As far as I can tell, the only people the current immigration system serves are immigration lawyers and bureaucrats. So we really do need reform. Also, as an American, a new one, as I said, I fervently believe that this is and should be the land of opportunity, and that if you are in this country and you are trying to make an honest living, that's perfectly fine. If you're not, then you should be, deported. But if you're just, trying to make a living and support your family, I think that's noble. And we should have ways for people of all, guest worker programs for unskilled, broader education, maybe points-based system for skilled workers like every other immigrant-accepting country in the world has. Every other immigrant-accepting country in the world makes it much, much easier to get a green card or permanent residence and much harder to get citizenship. Like you have to prove your Frenchness or your Germanness or something like this. And that makes a lot more sense because, why should we have a problem with people who are here to contribute to our country? And as I said, even the most unskilled illegal aliens are a net economic benefit to this country. Now, there are plenty of problems with the specifics of the Senate bill or whatever anyone can, my ideal solution to the broken system is different from anyone else's perhaps. I don't find, Kelly Ayotte or anybody else hypocritical because whatever happens, it has to be done through the normal process of law. Obama can't just change, the president can't just change the law, or else you'll have, President, Romney decide that he doesn't want to enforce, he wants to repeal Obamacare. President Rand Paul doesn't want to enforce the corporate income tax, or President Hillary Clinton decides that, whatever it is. President Ted Cruz doesn't want to enforce environmental regulations against Texas companies.
Here's one.
Whatever the case may be.
President Rand Paul decides to pardon all convicted marijuana users.
Well, he could do that. I mean, the pardon power it's not that Obama has pardoned all. There's actually a question of whether a president can pardon civil violations, which is what most of these immigration violations are. President Rand Paul doesn't want to enforce federal marijuana law or what have you, which is, a lot of it is illegal anyway, except the Supreme Court ruled incorrectly in Raich versus Gonzalez in 2005, but that's a different issue. Yeah.
You spoke about the fate of Ruth Bader Ginsburg. Switching over to our side of the aisle, obviously we're not going to have any Republicans...
I have no aisle. There are no classical liberals on the court.
Going to the Republican appointees, let's put it that way. None of them are obviously going to announce their retirement between now and January 20th, 2017. But assuming that we get a President Hillary Clinton, God forbid, what are the chances that a Scalia or a Thomas or a Kennedy decides that they've held on as long as they can and they have to retire?
Well, Scalia seems to really like his job. So I think, I don't think he'll be resigning. But he and Kennedy turned 80 in 2016. And Clarence Thomas has been gaining weight. I don't know. This is what we talk about. This is the state of our politics, that this is what we talk about, right? I don't know. The justices lead cushy lives. I don't know what the life expectancy is. It's not even statistically significant, right? So Kennedy certainly likes being the swing vote and kind of the conscience of the court or whatever. So I don't think Kennedy or Scalia are leaving anytime soon. I certainly don't think Clarence Thomas would leave voluntarily during a Democratic administration. Certainly not when he's in his 60s. Breyer is going to be 75 in 2016, I believe. So, yeah, I don't know. I understand that there are some clerks in Scalia's chambers who are charged with sweeping his office to make sure there are no loose cigarettes around. I don't think they put him in a chokehold, though. Yeah.
Well, Scalia said, in response to a question of mine in one of our meetings, I said Ron Paul had said that when he objects that something is unconstitutional, his fellow congressman would say, unconstitutional? Is that all you got? And I said, given that lack of deference, does Congress deserve any deference in their interpretation of the Constitution?
That's exactly a problem.
And Scalia said, yes, because they represent the will of the people.
Now,
He said,
Scalia likes to say I'm conservative, not crazy. And that's unfortunate, because if crazy is defined as hewing to the text of the Constitution, call me crazy.
Yeah, but what he did say was, do I think that they are concerned with the Constitution? Do I think they care about the Constitution? He said, not a whit.
Well, that's the problem, you see, because we have this vicious cycle of restraint, whereby the legislators say, let's pass this law. Who knows about this constitutional stuff? That's too hard. We'll let the courts deal with that. And the courts say, well, we'll just defer to the legislature. And that's how
Meanwhile,
government
the
power
Constitution
expands and individual liberty contracts. And this is the problem with conservative judicial pacifism, if you will, or judicial restraint. The response of conservatives in the 60s and 70s to liberal kind of making the law up as they go, rather than saying you're wrong on the law, was to say, how dare you overturn the decisions of the popularly elected branches, whether state legislatures or Congress. And that's incorrect. I think judges should judge and let the political chips fall where they may. And you saw this conservative judicial pacifism in John Roberts' vote in the Obamacare case, bending over backwards to uphold a law that's plainly unconstitutional. You can understand the liberals' view, right? There are no constitutional limits on federal power. Roberts' view isn't that view. It's we should bend over backwards to uphold what Congress does if at all possible. And that's a conservative view, and that's why I think conservatives long did themselves a disservice in arguing for restraint and minimalism rather than just what is the correct way to interpret the law.
Yeah.
Yeah.
Neither the liberal side or the conservative side has concerned themselves with individual rights as much as they concern themselves with state rights or federal rights. And the balance should be, what are the rights of the individual and how are they being trampled on by either the state or the federal government?
Well, I'm not sure that states or the federal government have rights; they have powers. But generally, to caricature. So I have my pocket constitution here. You can all get yours out. Mine though. So this is the Cato Constitution, right? It's a twofer. You buy the Constitution, you get the Declaration for free.
Yeah.
But this is the special limited edition Shapiro Wedding Constitution with our names and the date. And this Constitution has nothing cut out of it and nothing added to it. It also doesn't have any, emanations that form numbers or anything like that. So generally, conservatives like the structural parts. Liberals like the rights parts. I like all of it. And so, the 9th and 10th Amendment are the Constitution in a microcosm. Remember, we almost didn't have a Bill of Rights, right? Because Jefferson argued we didn't give the government any powers to invade any of our natural rights. Why do we need this? If we enumerate the rights, that implies that these rights are better than others. Madison said, oh no, I might be getting them confused after a few drinks of wine. Said no, we need to protect this, but we'll, as a compromise, we'll put in the 9th Amendment, which says that the enumeration of these rights doesn't deny or disparage others that are retained. The 10th Amendment that underlines that these really are the only power that the federal government gets, which is why I think, there's a lot of talk about constitutional amendments. I'm on an advisory council of various kinds of, Compact for America to have a balanced budget and the federal regulatory limitation, all these different things. Really, the only constitutional amendment we need is after every sentence to add, and we mean it, right? But that's, they're two sides. The rights and powers are supposed to be two sides of the same coin, as understood with the addition of the post-Civil War amendments. That before those, the federal Constitution only protected your rights against invasion or oppression by the federal government. The 14th Amendment, 13th with respect to slavery, 15th with respect to voting, 14th with respect to everything else, protected individual rights against state violation. And I believe that's true. I believe there's a constitutional right to get out of bed on whichever side of bed you want in the morning. I believe there's a constitutional right to wear a red hat. I believe there's a constitutional right to walk down to the right side of the street. all of these sort of things that we've gotten away from, because the whole debate over rights at the Supreme Court is whether a right is quote unquote fundamental. What's a fundamental right? Whatever you can get 5 votes for. It's kind of circular logic. All rights are fundamental. There's no, this is kind of the court bifurcated our rights in 1937, and then it took off all limitations on federal power in 1942. After that, it's Katie bar the door. So yes, I think both conservatives and liberals are at fault, and I do believe that just as it's taken 7 decades and more for constitutional law to deviate so much from the Constitution, it's going to take just as long to get it back in the right place. Yeah.
You mentioned before about the gay rights case, the gay marriage case, that Cato prefers that the government be out of marriage altogether, but if it's going to be in it, that they should apply equal protection. What are the chances of the court saying just what Cato's position is and saying, listen, there is no constitutional reason for the government to be involved in marriages, and just wiping the slate clean?
Oh, it can't do that, because that's not the question that's going to be presented to it. It can't just strike down state marriage laws. I mean, that's not the challenge. It's not someone challenging, saying, the state should be out of marriage. They want the licenses. And given that almost certainly Justice Kennedy will be writing the opinion, who knows what people will be arguing about what exactly he said when he wrote that. So no, they're not going to take a policy position about government should be out of marriage. I think it's more likely than not that at least the plurality will decide the case on equal protection grounds rather than substantive due process. I think Justice Scalia, therefore, was right in his dissent. His dissent in Windsor has been quoted a lot by the lower courts that are striking down state marriage laws. He said that the logic of Windsor striking down that section of DOMA can be equally applied in parallel to state marriage laws, and it has been. I think he's right about that. But he had a prescient dissent in Lawrence versus Texas as well, the Texas homosexual sodomy case, where he said that the controlling opinion, by the way, was Justice O'Connor's equal protection opinion, and he said that logic would mean gay marriage around the country, and I think that's what's going to happen.
Do you think the genie's out of the bottle on gay marriage?
Absolutely. And I'm sort of disappointed that some very conservative traditional state like Mississippi or Utah or Oklahoma didn't pass some contingent legislation saying if the federal court strikes down our law, we will get out of the marriage business. Because I would have seen that experiment in federalism, but they decided not to do that. Yeah.
Are you familiar with a case in the 1980s? It was called Hawaii Housing Authority versus Midkiff.
Mm-hmm.
That decision really bothered me, and it troubles me.
You were 2.
Yeah, really.
I was 8.
He wasn't born.
Well, I know. I wasn't alive yet, but I'm just saying that it still holds precedent to this day, and it's very troubling.
This is a property rights case that interpreted blight to mean underdevelopment, essentially. And yeah, it is troubling. It's led to it led to Kelo, among other cases that have allowed governments to condemn private property because it thinks that some other private developer can use it for a higher value use, and higher value means
a Rite Aid.
A CVS, no, not a CVS instead of a Rite Aid, a Neiman Marcus instead of a Rite Aid.
No, I think it was 2 drugstore chains in one of these cases.
Well, those seem kind of equivalent to me. But anyway, so certainly that is that plus the Poletown case out of Michigan. Those were certainly precursors to the Kelo decision, which is celebrating its dubious 10-year anniversary next year. Have we not drunk all the wine yet? There's still more questions?
The wine.
Yeah, I would just add one
Look,
comment.
there's gin here. Can I bartend? Is that I'm a full service speaker,
I would just add one comment to what you're saying. We're kind of sitting here lamenting the fact that nobody pays any attention to the Constitution anymore. It's Nancy Pelosi, are you serious? One of the exercises I did was go back and read all the State of the Union addresses all the way up to the Civil War. and I was struck by, I believe it was Madison in the early 1800s, pleading before Congress for a constitutional amendment because they needed to build roads so that they could get from the coastline where they would be pirates and marauders to the frontier where they had Indians, and it was existential. And yet, without that constitutional amendment, he didn't have the authority to do it. He wouldn't even dream of doing it.
In 1889, Grover Cleveland vetoed an appropriation of $10,000 to for seeds to farmers in Texas during probably the worst drought in our history because he could not find a warrant in the Constitution for it. And yeah, there's been inflation, but that $10,000 isn't that significant even now, adjusted for inflation. And now we spend, sums hundreds times greater going towards clearly non-interstate sort of things. I mean, interstate commerce, forget the interstate part. Commerce, the definition of commerce in the framing era actually meant trade in goods. It didn't mean manufacture or agriculture even. It didn't mean anything with a dollar sign attached to it. So yeah, if we actually interpreted the Constitution as it was meant, the federal government would be much smaller, or we'd have a bunch of constitutional amendments expanding its power.
The case that set the precedent for interstate commerce in the country was a case, if I'm not mistaken, you'll tell me if I'm right, dealing with minnows in Oklahoma, correct? The fishing of minnows in
No.
Oklahoma?
It's much before that. You're talking about the Delta smelt,
You're talking about
which I
Wicker?
think is in California. There might be
Yes.
other types of species in Oklahoma,
You're
but
talking about Wicker,
no.
right?
In Wickard versus Filbur in 1942, a farmer in Ohio was, a local subsistence farmer, and the Agricultural Adjustment Act came along that set prices for agricultural crops, which caused a lot of shortages and really wrecked the markets. But that's beside the point. And Mr. Filburn said, I shouldn't be subject to this requirement. I don't engage in interstate commerce. I feed some of this stuff to my cows, and I eat some of it. I make it into bread, and that's about it.
Personal
And the
consumption.
court ruled that in this 1942 case that if all the farmers acted like Mr. Filburn across the country, that would derail the national policy on agriculture, and therefore his decisions, even if local economic activity, has a substantial effect on interstate commerce. And that is what opened up federal regulation large scale.
Maybe one more question so we can go back to drinking the wine?
And feeding me. I mean, so far, my lunch I think was the maraschino cherry and an old fashioned that I had, and then so far dinner has been these hors d'oeuvres, which are delicious. But
If nobody else has anything, and I'll defer if they do. Does anybody? No? I would like, it's very clear where you stand on immigration. The question I would have is how you reconcile that with national security. In other words, we're not talking about open borders. We're talking about secure borders where anybody that we know who they are
certainly.
can come in. Yes?
Certainly, you screen people, and if they're up to no good, if they don't have a job, if they lose their job, 30 days later they have to leave the country, that sort of thing.
So it's not
If
an
you-
open borders. It's
Well-
a secure border, but anybody
Well, it's
can come
controlling
in.
your sovereignty, certainly, but it's a matter of redirecting resources away from going after people who are working illegally to going after people who are, committing violent crimes or engaged in terrorism or are public health threats or actual national security problems. Absolutely, it's prioritizing your prosecution. This is why I have a problem with E-Verify, for example. I mean, think about what E-Verify is. You think, well, that's a good
It's
system of telling
protectionism.
who's legal or not. It's not even the protectionism bit, but think about it. That means everybody in the country, not just someone who looks Hispanic or looks illegal, whatever that means, right? Everybody in the country has to ask the federal government for permission to work.
Right.
That's ridiculous. They have to, and there's some false positives and false negatives, but you're asking the government to run your social security number against a database before you're allowed to earn a living.
Except
That's
for
un-American.
Obama. Except for Obama.
Yeah.
Well, thank you.
Thank you.
All right, thank you.